believe you're entitled to 10 minutes of oral argument. If you wouldn't mind putting your name on the record, please.
I'm the executor and sole beneficiary of the trust and estate of Mr. Kevin Dwayne Craft, the legal persona.
Well, Mr. State of Mr. Kevin Dwayne Craft, the legal persona, what level of stupidity will you be taking us to today? Because every time a sovereign citizen steps into a courtroom, we know we're about to be dragged through a maze of pseudo-legal nonsense that not even Google Translate could make sense of. Hey everyone, and welcome to today's video. Buckle up, because this one is special. Our sovereign citizen of the day has done the unthinkable. He dragged his case all the way to the Michigan Court of Appeals. And not for the classic right to travel argument. Not for claims that driver's licenses are unconstitutional. And not even for the usual speech about his name being a corporation. No. He went to the Court of Appeals to defend what he believes is his sacred right to be a deadbeat dad. Yes, really. He actually argued that the state of Michigan has no jurisdiction to make him take responsibility for the children he helped bring into the world. Because apparently, if you just declare yourself a private, individual, or non-citizen, you can magically exempt yourself from parenthood. So, today we get to watch the Michigan Court of Appeals sift through his sovereign citizen. Ramblings with the patience of saints and the facial expressions of people who deeply regret choosing a career in public service. It's the perfect blend of cringe comedy and complete legal delusion. Let's begin. Because Kevin Crazy Craft is about to show us just how far someone will go to avoid basic responsibility, while the judges show him exactly how jurisdiction actually works in the real world.
I'm not here making a general appearance. I'm here by special divine appearance, judge, to settle a matter, to call for a constitutional court of record to ask for a summary judgment upon the truth and facts that I placed upon the record with my documents. I stand firmly on my rights, and I'm here to ask for the summary judgment, please.
What you asked for?
I do also have a few questions.
I understand you're pro se, and then therefore you get a little bit of leeway, but typically the judges don't answer questions. We're the ones who ask questions. This isn't like a trial court where it's a very kind of back and forth. The Court of Appeals is more structured in terms of the lawyers or parties come up, they make their arguments. The judges may or may not have questions for the person, and then it's submitted, and then we go back and discuss the matter, and then at some point in the future we come out with an opinion. So it is different in that respect than trial court.
Understood. But I am wondering if this is a court of constitution, and would the Constitution be applied in these proceedings?
The Court of Appeals, the Michigan Court of Appeals, is provided for under the state Constitution of 1963.
Is that a yes?
That's the answer I'm giving you.
Okay. I'm asking to verify to make sure these proceedings are legitimate. The Constitution has two jurisdictions: common law, admiralty law, or maritime tribunal. And I'm asking in which context would this court try to enforce jurisdiction on me?
Hold on, so let me get this straight. You dragged your own case all the way to the Michigan Court of Appeals, filed the paperwork, submitted the arguments, demanded your day in front of the judges. And now you're standing here asking whether they have jurisdiction? That's like walking into a restaurant, ordering a steak, eating half of it, and then announcing you don't recognize the authority of the waiter. And since you ask about context, here it is, in the simplest terms possible: the court's jurisdiction over you is both personal and statutory. Personal, because you reside in the state and are subject to its laws, whether you call yourself a private man, living soul, secured party creditor, or sovereign citizen extraordinaire. And statutory, because child support, paternity, and family law obligations are explicitly written into both the United States Constitution and the Michigan Constitution, along with the state's entire legal framework. In other words, jurisdiction isn't some magical contract you can opt out of by reading half. It's a blog post and declaring yourself free from responsibility. It's the legal authority the court already has owned that you voluntarily invoked the moment you filed.
Acting under the state constitution of Michigan of 1963.
Moving forward, I'm here to pretty much address the court's error for ignoring my motions. Notice of dismissal, default judgment under Federal Rule 55 was filed December 12, 2022. Under Federal Rule 55, if a party fails to respond to the defendants themselves, and this is confirmed by my affidavits, and other means, the clerk must officially record a default judgment of that party. I filed several motions and they were ignored. That's why I'm here. In Haynes versus Kirnar, 404 U.S. 519, 1972, courts must be understanding and not easily reject motions from people just representing themselves. And that's what took place in this.
But is it though? Haynes v. Kerner is one of those cases sovereign citizens love to throw around because it sounds powerful if you only read the headline. Yes, the Supreme Court held that a pro se litigant's civil rights complaint can't just be tossed out without giving them a chance to offer evidence. But here's the key part. You're ignoring. Haynes was about an actual civil rights claim, real allegations of abuse in a prison setting. It wasn't about someone trying to dodge child support and disguising it as a constitutional crisis. You didn't get denied because the court violated your rights. You got denied because filing a stack of pseudo-legal nonsense doesn't magically turn your personal obligations into a civil rights violation, and in your painful-induced fantasy of legal enlightenment. You seem to think your situation rises to the level of actual constitutional harm. It doesn't. The court didn't overlook your claims. They looked right at them and recognized them for exactly what they were: frivolous, irrelevant, and completely unsupported by anything resembling real law.
Section 17 of the Michigan Constitution prevents courts from ignoring motions and guarantees that people have a fair chance to represent themselves in any argument and evidence. That did not happen. That's why we're here. The state ordered me to take a paternity test. And Monell versus Department of Social Services, which is a New York State case. The Supreme Court case established that municipalities' liability under the section 1983 for constitutional violations in the context of child support cases, where the appellant argues that a warrant should be required for me obtaining genetic and biological material. I think it's very sensitive when a state injects an order asking me to give genetic and biological material without a warrant. That's really sensitive material. It's not like a document or anything. That's personal biological material. That's why those specimens were not granted. That's why I denied any consent or any contract with the state or Title 4D agency to give away my biological and genetic material.
Oh? So that's what this whole performance really boils down to. This isn't about sovereignty, jurisdiction, constitutional wizardry, or whatever new phrase you pulled off a YouTube comment section. You just don't want to take care of your kids or pay child support. So you slapped on the sovereign citizen costume and hoped it would magically erase your responsibilities. All the "I do not consent." State has no authority, and I am the executor of my own vessel. Nonsense was never a legal argument. Tit was a dodge. When the bill came due, instead of stepping up like a parent, you pivoted to pseudo-legal fantasy land and hoped the court would get confused.
Relevant because it underscores the importance to ensure that government agencies like the friend of the court, or in this context, these are for-profit agencies disguised as government agencies like the friend of the court, adhere to constitutional standards where collecting evidence potentially implying the need of procedure safeguards to protect individuals' Fourth Amendment That's why I asked, was this a constitutional court? The asking for genetic material is protected by my Fourth Amendment right. The Fourth Amendment protects individuals from unreasonable searches and seizures and safeguards one's privacy and assurance that any such search is conducted within the boundaries of legal requirements.
Michigan Compiled Laws Act 205, better known as the Parenting Act, spells all of this out in plain English. It explicitly authorizes the state to obtain your DNA in cases involving paternity, child support, or related disputes. It also lays out how that DNA can be collected and exactly what happens when someone refuses to cooperate. So while you're busy shouting about jurisdiction, sovereignty, and imaginary loopholes, the law you're trying to sidestep is standing right behind you with a clipboard and a court order.
They're not here today, and that's some questions that are raised, and those were my concerns. On August 11, 2022, the Kent County ordered an appointment for me for genetic and biological testing. In a testing laboratory, DNA Diagnostic Center is a business, and I can prove it's a business because I have their Dun and Bradstreet numbers. 877-184226 for the record. They also said, when I thought this was funny, the state of Michigan stated that it would pay the cost of the genetic test. And if I wasn't excluded, that I would be responsible for that cost. And with that being said, that set alarm.
Let me guess. The instant that letter showed up, some little alarm in your head started shrieking, "Oh no, this is gonna cost me money. And they're still gonna prove I'm the father." Because that's really what all this quantum grammar, sovereign traveler jurisdiction denial nonsense boils down to. Not philosophy, not freedom, not rights. Just a desperate attempt to dodge a bill and a DNA swab. And spoiler alert, the state already knows how this story ends.
And it's also a business. And with them fronting the cost for me, that presented an alarm for me because I don't choose the contract with the state of Michigan. I don't choose to do business with them in this regard with another business. It seems like a coercion of some sort for them to upfront the cost. If I was going to be responsible, I do not consent to that business arrangement. The state, they failed to show a promissory note of a contract of any sort. I submitted documents, notice to the court to demand dismissal for lack of jurisdiction, demanded to see an open court evidence of personal and subject matter jurisdiction, and notice of court to refusing to appear voluntary. And I do not accept the offer to contract, and I do not consent to these proceedings. That affidavit or notice to motion was submitted on November 28th, 2022. So again, I'm just bringing up the point that I submitted numerous of documents asking for clear evidence or asking for due process, also asking for just quite frankly, to be transparent with what's happening. And I believe I deserve the right to see in writing what gives them the authority and what contract am I entering. I want full.
Exactly. Michigan Compiled Laws 205 doesn't leave anything to guesswork. It lays out, in plain legal terms, the full framework for paternity testing, when it can be ordered, how it's to be conducted, what methods are permissible, and what happens if you refuse or obstruct the process. So all that sovereign citizen theatrics about, "they can't touch me," or "you have no jurisdiction," doesn't hold water. MCL 205 gives the court clear authority, and the procedures are designed to ensure fairness, transparency, and accountability for everyone.
In Burns 322 BR 719, a creditor must provide proper documentation such as a promissory note, contract to substantiate a debt or court claim. They did not. More documents I filed. Affidavit inserting corporate nature of government entities. I submitted that document. because I'm concerned that these are for-profit businesses disguised as government agencies. I have proof. Kent County Court, Dun and Bradstreet number for the record, 152906082. Kent County Friend of the Court, Dun and Bradstreet number, 6088333133. State of Michigan, Dun and Bradstreet number, 504698428. These are businesses. I would like to state for the record that I am not a corporation.
Exactly this is the kind of over-the-top nonsense that earns someone a gold star in stupid, dumb information of the day. He's claiming all these irrelevant things about being a corporation. Legal fictions, or whatever sovereign citizen mumbo-jumbo. When in reality, none of it changes the legal obligations in front of him. It's almost impressive how much energy he's putting into being wrong. And it's exactly the kind of behavior that makes these court videos simultaneously frustrating and entertaining.
I'm a living, breathing person, human being. With these being businesses, they have to abide by the same rules as other businesses. And may I give an example? For example, McDonald's. McDonald's can't force me to eat their Big Macs. They need my consent. None of these businesses that I've mentioned have my consent to do business with them. Section 458 of the Social Security Act, incentive payments to state. It's a conflict of interest. And it's my argument right here, right now, that the state incentivizes them it incentivizes them to collect more child support.
The state doesn't play Santa or a debt buyer. It's more like a middleman, making sure that the money you're legally obligated to provide actually reaches your kid. When you pay child support, it's not some abstract punishment or a way for the government to profit off your failure. It's literally ensuring that your child's needs are met. Think of it as the court holding you accountable for your responsibilities, so that the kid doesn't suffer because you decided to act like a sovereign citizen and ignore reality. The state's role is enforcement and protection.
The main argument I have here and for you guys is full disclosure. It seems like they enter me in a contract without my consent, without full disclosure, and that's the problem here. I'm here to argue subject matter and lack of jurisdiction. No evidence was established in my involvement of a common law crime or damages, and I did not commit any common law crime. Notice of court to refusing to appear voluntary, and I do not accept these contracts, and I do not consent to these proceedings was another motion or notice to motion that I submitted 11/28/22, and it's evidence they didn't provide any evidence of an injury or injured party, and
Mr. Kraft, you're out
yes.
of time. We understand that you raise issues of disclosure,
Yes.
jurisdiction, remedy, and as I indicated, your brief, as with all the appellants and appellees we have here today, the briefs that you submit are kind of the key issue or the key tool that we use to resolve cases. And so I just want you to know, we have your brief.
Mm-hmm.
We're going to go back. We've had research attorneys look at it. We're going to look at it again. We're going to discuss your case. And then you'll get an opinion from us sometime within the next few weeks.
If I may, one last thing.
You've got, if you can do it in 20 seconds.
I can. The government must prove charges beyond a reasonable doubt with clear evidence, especially when making the claims against someone. And I'm asking you guys right here, right now, they did not provide any evidence against me. And I would ask you to...
Got it? Here's your paragraph version, cleaned up and flowing as one. I'm going to assume that both the long and short answers are going to be the same. So that's the end of the video. Like the judge said, there will be a decision made in a couple of weeks. And as long as it's public information, you know I'll be there to report on it. The sovereign citizens lost, so if you liked the video, leave a like. If you disliked it, leave a dislike. But don't forget to leave a comment below and subscribe with notifications on so you don't miss any of my content. I'm on Team Skeptic, and I'm out.